allegations in a speech to a bar. One is you shouldn't speak to the bar at all, end of story, go home. The other is that the speech was so, whatever, it was not pleasant for someone or the other, and nonetheless it was made. Now the content is either true or false. It is admitted on all sides that the Supreme Judicial Council did not inquire into the matter. The word inquiry, Khan Sahib has said, is finds mentioned twice, 5, again in 2096, and 2097 says you can't remove it unless this. Okay? To proceed further, you have to inquire into the matter, not to finish a complaint. If the complaint was consigned to the record, that's not the issue. But when you are proceeding against a judge, then Khan Sahib has said, where is my due process? Where is my right to, if everybody comes before me asking for right to fair trial. Now we come to the situation, where do we go from here?
And the most important thing is that the allegation has been leveled against the institution, which is more important as far as I am concerned. ये इसके तहकीकात होनी चाहिए या नहीं होनी चाहिए, अब सवाल में उड़ा.
और एक चीज और, ख्वाजा साहब has also said one more thing, something important. He said once he's been removed and he's attained the age of superannuation, the matter ends. Now, we were hearing some other case.
Yes.
The same issue came up there also.
So, my lord, as far as not following or not conducting the inquiry is concerned, that is contrary to law, and that to my mind would be malice in law, and therefore Article 211's ouster would not apply as far as this petition is concerned. Which ouster? 211, sir. Article 211.
What does it say?
Bar of jurisdiction.
Bar on jurisdiction, my lord.
The number of judgments you said.
So I think that's quite settled. So if the inquiry hasn't been followed, on the basis of it being there being malafide in law, Article 211 does not apply. Therefore, this court would have jurisdiction.
Malafide in law.
No, but malafide in law is basically if the process is not followed. If what the law or the constitution requires is not followed, it is malafide in law. Not in fact, but in law. So because if that is so, then this court has jurisdiction, so the court can proceed. The court can look into the movement.
We are not a substitute for the Supreme Judicial Council.
Of course you're not, but the question...
We can't say, okay, now please come and give oath and give it on statement,
this is
will cross-examine.
No, this is jurisdictional question. This is jurisdictional question. You're not going to inquire into the matter while sitting as a court. The Supreme Judicial Council's, it is Supreme Judicial Council's remit to look into that matter, but I am just only saying that this court has jurisdiction to hear the petition if the inquiry has not been conducted, 209, and the procedure has not been
crossed
followed.
that bridge.
So yes. So once that is done,
where do we go from here?
Once that is done, now one fact which was alluded to, and there is a judgment, a two-member bench's judgment in Afia Sheher Banu Zia's case, BLD 2023 Supreme Court 510, wherein the two-member bench has held that if a judge has resigned or has retired, the proceedings, if while he was on the bench had commenced before SJC, they would abate. Now, the federal government, I had in another matter stated before your lordship that the federal government intends to file an appeal against that judgment.
Has it been filed?
Yes, my lord, it has been filed.
What number hai?
My lord, it has yet to be numbered. I hope it will be numbered today or tomorrow. Now, there are several problems with that judgment, and of course...
If the principle of that judgment is sustained, then it effectively cuts both sides. Then a judge who's been unconstitutionally removed can do nothing.
Now, so in this,
if in the meantime he retired, for instance,
so in this case,
he attained the age of superannuation.
So in this case, the distinction also is that after the judge was, the petitioner was removed, he had essayed those proceedings before this court, and he had not attained the age of superannuation at that time. So that distinction being there, but that judgment needs to be revisited also by this bench or any other bench in order for the court to then pass the order of setting aside the Supreme Judicial Council's order in this case also.
Yeah, I'm not clear with you. Are you saying that we should attach that case with this case?
I would submit so, my lord.
Acha. Okay.
And now, if the inquiry process has not been followed, and the allegation, now we don't know what
Is remand permissible?
If, my lord,
If you are saying if Afia is sustained, then it probably may not be. Is that what I'm not understanding?
if Afia is sustained, then perhaps in this case, they may still have to, the petitioner may still have an argument to make, which is that he had not attained the age of superannuation when he had challenged the Supreme Judicial Council's order before this court. So there would be that distinction.
I think there is a fact is that the list in some form or the other was before this court.
That's right. So that's what I was alluding to. That if there would still be a distinction as far as this particular case.
If we accept this petition,
Yeah.
what will happen? So we will simply
Things can happen. Two things can happen. If my lords accept this petition and simply set aside the Supreme Judicial Council's order without remanding it, then he would be treated as a judge who had retired.
We are also concerned about the allegations. What would happen to the allegations?
Suppose, with due respect to the petitioner and his counsel, suppose we set aside the order and he is laughing. All that I said was false. Okay? Nation, I think I'm more concerned that every case we decide we have to keep half an eye out कि भाई इसका implication generally क्या होगा. You may want to do something, but it may have wide ranging implications. The other thing is, doesn't the nation want to know one way or the other? What is the position of the federal government on this? Wouldn't you want to, as they say, get to the truth of the matter?
My lord, so I just got called on short notice, but
I know that's not fair.
What I can state here is that now there are certain allegations which are made in this petition, and those allegations, from what I've understood while sitting here, have been denied.
Not some minor allegations, some serious allegations.
Those allegations have been denied, and now obviously this court cannot record evidence. Is not the forum for doing it. Is there a solution? The solution, my lord, is that in order to look at the entire matter in totality, if Afia Zia is overturned and this matter is remanded to, the order of the Supreme Judicial Council is set aside and the matter is remanded to Supreme Judicial Council, then as far as the inquiry of these allegations is concerned, that perhaps is the only forum.
And then question arises that the man has retired. What will happen?
So for that purpose, you have to overturn Afia Sherbanu Zia. For those purposes, you have to first, this court has to overturn Afia Sherbanu Zia in order to cross that barrier and then go to
this case is slightly different. He was not retired at that time.
That's right. He was still before the court. Now the question would still be that if the petition is allowed, what could be the consequence? Now if limited consequences
जल्दी डिसाइड हो जाती है इनकी रिटायरमेंट से पहले तो मसला हल हो चुका
वो भी हो चुका होता, बट अगर फॉर एग्जांपल एक ये हो सकता है कि जी पिटिशन आप अलाउ कर दें एंड he is treated as a retired judge and thus entitled to all the benefits which a retired judge is entitled to. But if on a broader scale, so on a broader scale, then I think since he has retired and now that
is what's troubling me. Let's suppose a complaint is filed against a judge 1 month before his retirement. And the Supreme Judicial Council, without saying he's corrupt, Supreme Judicial Council, without inquiring into the matter, recommends to the President, reports whatever, remove him. He's removed. Now, naturally, when he filed the petition, he's already retired.
That's right.
So I don't think the date would there be. He has got no way to vindicate his honor.
There has to be a way. There has to be a way.
Basically, you are saying one way is no, too bad, whether the Supreme Judicial Council inquired into the matter or not. I mean, whether we agree with the findings of the Supreme Judicial, that's a separate matter. One is at least inquire into the matter. Okay, I may have a higher level of proof, another may be lower, but leaving those technicalities aside, basic inquiry has to be conducted of some form or the other.
Absolutely.
I mean, whether it has to be in accordance with the Qanun-e-Shahadat or...
No, it's the Constitution requires so. I mean, a judge cannot be removed without
Are
inquiry.
judges entitled to fundamental rights or not?
It is? Absolutely. I mean, it is at the heart of independence of judiciary. Absolutely. Absolutely. At the heart of independence of judiciary has
इसका solution क्या है फिर?
So इसका solution to my mind
आप
is
कह रहे हैं कि इसको क्लब करें उस केस के साथ?
उसको overturn करना जरूरी होगा because that would then settle the law. Because in this case, obviously there was a substantial period of time when the petitioner was removed.
लेकिन बात कहाँ से कहाँ connect हो जाती है?
And his
Nobody could have thought this would connect there.
About 3 years.
So if he had 3 years to his service left.
No, लेकिन like I said, suppose he had only 1 day left.
Yes. So in that hypothetical,
I mean,
then obviously,
I don't think that's really crucial aspect.
So in that hypothetical, which my Lord has just pointed out, I think it is necessary that that point is settled. That the point is settled that even if he stands retired and attains age of superannuation, the matter can still be revisited by
because that delay we are accountable for in this particular case. Because it's proceeded so long. We can't fault the petitioner on that.
Oh, absolutely not. Nobody can.
So, कितनी hearings हो गई थी इसमें?
बेशुमार सर, many hearings.
हमने कितनी दफा सुना?
Last hearing was.
मैंने कहा आपका इल्जाम हम पे तो नहीं है, हमने कितनी दफा सुना इस केस को?
तीसरी सर। ऑर्डर शीट दूसरा मैं आपको ऑर्डर शीट दिखाऊं तो
ये दूसरी दफा है, हम मेरे साथी याद दिला रहे।
But we are responsible for our senior.
अक्टूबर 2018 में ये पिटीशन फाइल
2018
नहीं वो क्योंकि वो पार्टी नहीं बनाया था ना, उसमें भी टाइम लगा। वो आपका कसूर था खान साहब, थोड़ा हमारा कसूर था मगर वो आपका कसूर था, मान लीजिए, क्योंकि आपने एलिगेशंस लगाई थी अगेंस्ट पीपल हु वर नॉट बिफोर us, so we had to give them a notice. So that goes in your we don't accept responsibility for that.
But the question that even shows that this was a case.
Wasim Sajjad Sahab, can we benefit by your acumen? Have you been following what we are talking about? What is your view? Can it be remanded to the Supreme Judicial Council or not?
But actually, I haven't studied this matter. I wouldn't like to make a comment without going through studying it properly, because it's an important question. But I would say that the Supreme Court of Pakistan is the highest court, and there's nothing in the Constitution which prevents it from remanding the case back to the Judicial Council. But as I said, I would like to study the matter further. Once the matter is before your Lordship also has the power to do complete justice under Article 187. So there is no impediment.
आपकी अपील कब लगी है?
My Lord, it's been filed earlier today. I think it will hopefully be numbered today. And once it is numbered, I think it can be fixed whenever the office fixes it.
Point that you want to say at this juncture? Anyone, any of the council or?
This is one of the exceptional cases. Earlier cases, like Justice Shaukat Ali's case, there was a detailed inquiry held. And after that, the Supreme Judicial Council submitted to the President to remove him. There have been even earlier cases Akhlaq Hussein's case where inquiry was held. This is the first case of risk nature where no Supreme Judicial Council did not hold any inquiry into the allegations. So therefore my submission is this goes right against the independence of...
No, can you cite those cases, the earlier cases, where inquiries were held?
One is Justice Shaukat Ali's case is PLD 1971 Supreme Court.
1971 Supreme Court,
Page 585.
585. And here you are saying the Supreme Judicial Council did hold inquiry.
Hold a very lengthy inquiry, some 80 witnesses and so on. So
Recommended the judge's removal.
remove.
As in the next cases, this is Justice Shaukat Ali.
Earlier case was Justice Akhlaq Hussein's case, PLD 1960 Supreme Court. Yeah, page there, 26 perhaps.
जी
अच्छा उसमें
नहीं वो पेज नंबर अखलाक हुसैन हम ढूंढ लेंगे, चलें खैर अगला वाला बताते हैं। कोई और भी केस है?
ये दो केसेस हैं जहां पर सुप्रीम कोर्ट जज वाज रिमूव्ड आफ्टर ड्यू इंक्वायरी। नाउ सर एक और बात, 1956 का मैंने कॉन्स्टिट्यूशन एग्जाम देखा है, उसमें कहीं इंक्वायरी की रिक्वायरमेंट नहीं थी एज सच, बट inquiry was held.
Which was that provision of 56 Constitution? Which article?
Earlier article was 128.
128.
60, under the 60.
Article 128, Supreme Judicial Council, which did not specifically mention the word inquiry.
It mentioned inquiry. Article 128 was in the same terms as Article 209. But I'm talking about 1956 Constitution. Under the 1956 Constitution.
किसमें नहीं था?
ये इसमें नहीं था अखलाक हुसैन वाले केस में, स्टेट वर्सेस अखलाक हुसैन।
नहीं, वो कौन सा आइन था जिसके आप जिक्र कर रहे हैं?
56 का।
उसमें नहीं था?
उसमें ये नहीं था कि इंक्वायरी जरूरी है।
उस आइन की कौन सी शिक थी?
उस आइन की शिक थी आर्टिकल 169।
69।
169।
अच्छा 169।